Good morning and welcome to our latest installment in the Green Broilette and Wheeler webinar series, GBW, Our Method for Success. How did you win that case? Today we'll focus on the case of Coronel versus Quest Property, which settled on the eve of trial for a confidential amount. I handled that case along with my partner, Ivan Pouchalt. For those of you who don't know me, I'm Scott Carr, a partner at Green Broilette and Wheeler, where I've practiced for more than 30 years. I specialize in business litigation, legal malpractice, personal injury, and product liability. I'm a past president of the Association of Business Trial Lawyers in Los Angeles and a longtime member of CALA and CAOC, amongst other organizations. I'm proud to have been named Consumer Attorney of the Year by this Consumer Attorneys of California in 2016 for my work as co-trial counsel on Aaron Andrews versus Marriott. I would also like to introduce my partner, Ivan Pouchalt. Throughout his career at Green Broilette and Wheeler, Ivan has won several high-profile cases involving public safety and the rights of whistleblowers, earning him nomination for Trial Lawyer of the Year from CAOC in 2013, 2014, and 2018. One of the cases that Ivan was nominated for was Burke versus City of San Diego, which is a tree case that we'll be discussing here today. His trial practice focuses on catastrophic personal injury, product liability, wrongful death, municipal liability, and employment, although I personally have to say that I think Ivan is the preeminent lawyer in tree failure cases in California. So I'm proud to have him on the panel here today. Before we start, I want you to put on your calendars January 21st of 2021 for our next webinar in the series, which will feature Bruce Broilette and Alan Van Gelder. It's regarding a confidential mid-trial settlement for a fall through an unguarded skylight. So there are significant prevent issues discussed there, so you won't want to miss that. Very topical and very timely today. Also, the final thing before we begin is during the presentation, if you have any questions, just type them in. We'll try to get to questions at the end and answer whatever we can for you. Also, in the lead up to this morning, I was having some internet issues. So if for some reason I happen to tune out, Ivan will just fill in, but I apologize if that happens. Hopefully it won't get to that. So we've all heard the age-old question, when a tree falls in the woods and no one's around, does it make a sound? Well, today's webinar answers the corollary, which is if a tree falls in the city and someone is around and gets hit by the tree, can they recover for their injuries? As you'll see, the answer here is oftentimes yes. So at 4:30 a.m. on February 1st, 2016, the plaintiff in our case, Marie Coronel, and her cameraman, Mike Gold, were sent by her studio, KGTV Channel 10 News, to prepare a report on the aftermath of a severe storm that had passed through San Diego the previous day. Arriving at Maya Linda Road near the Quest property, which was owned and managed by the defendants in the case, Marie found 4 very large downed eucalyptus trees. The 4 trees, which had lined the edge of the Quest Condominium Complex along Maya Linda Road, had fallen across a green belt that surrounded the condominiums, across the sidewalk, and out across the adjoining road. At the time Marie arrived, by all accounts, the storm had ended and there was little to no wind and no rain. Why don't you cue up the video and you can take a look at the broadcast that Marie did about 15 minutes before this incident occurred.
All right, well, the powerful wind knocked over trees that came crashing down on cars.
Yeah, 10 News reporter Marie Coronel is live in Mira Mesa. Bad situation there, Marie. Do the car owners even know what happened to their cars overnight?
You know, Virginia, since we've been out here, I haven't seen any car owners coming out to check on the damage. Right now, I'm going to show you kind of what happened. Right there, I'm flashing the light. That is where the tree was uprooted. You can see how large that is, almost reaching the top of that patio. If you follow this all the way down, this tree fell all the way across the street, and the extent of the damage, it varies. So you have the debris, you have tree limbs right here. You look at this car. Okay, so you have a little bit of damage here, but it's when you walk over across the street where you see just crazy stuff. Right here, look at this pickup truck. So the tree fell all the way across the street, smashed this truck, and there's even more damage on the other side. Look how low it's gotten already, you know, with the truck, the level of that with the tires. And, you know, looking around, this is an apartment complex, so a lot of folks, they have limited parking, so a lot of people did park on the street. And if you see, I mean, just this mess, police have this road blocked off. No word yet as far as a cleanup, but as you can see, a lot of cleanup for the folks in this neighborhood. We're live from Mira Mesa. Marie Coronel, 10 News.
Wow, Marie, thank you. This is something we also saw on
So just so you can all get an idea of what was going on there, that was a hit that Marie had done shortly before the incident occurred. They were lining up to do a second hit when the tree fell, and we'll talk a little bit more about that in a second. But I want to get you oriented in terms of where she was and what you saw and ultimately how this occurred. So if you look at the slide, you can see the condominium complex, which is the Quest condominium complex where the trees had fallen down that you just saw in the video. You can go to the next slide, please. So if you look in the left center of the photo is Maya Linda Road, which is the road that abutted the condominium complex. And if you look in the middle, Ivan, if you can point to where the tree was. So where Ivan's moving the cursor is where the tree was that actually fell in this case and hit Marie Coronel. You can go to the next slide, please. So this is a close-up of the tree, which is tree number 10, which we'll talk about in a little more detail, but ultimately that's the tree that fell and hit Marie. So you have a little bit of an orientation and a little bit of an idea, and so we'll go a little bit further into the story. So hoping to capture the scene that they had confronted, Marie Coronel and her cameraman picked a location within the greenbelt just off the sidewalk in between two fallen trees. Can you go to the next slide, please? So if you look at the two trees on the very left-hand side of the photo, those are the trees that had fallen, and it was in between those two trees where Marie was standing at the time that the incident had occurred. So Marie and her cameraman believe this spot effectively showcased the property damage and collection of the 4 downed trees as they extended all the way across Maya Linda Road, and you can see the trees in this photograph. To get to the location, Marie and her cameraman entered an area with some caution tape, partially lying on the ground. It appeared to the cameraman, Mr. Gold, that the tape had been positioned to caution drivers not to drive into the trees which had fallen onto the road. The tape had no significance to Marie or to Mr. Gold because the tape was on the ground. We can go to, so you can see in this slide the trees that had fallen. And then if you go to the third tree in, which is the tree that fell on Marie, and then go to the next slide, please. So the next slide is a sketch that was prepared by the Cal-OSHA investigator, but it gives you an idea as to the 2 trees that had been down, where Marie and Mr. Gold positioned themselves. And then you can see what's marked as tree number 5 on this sketch is the tree that actually fell and hit Marie and Mike Gold as they were preparing to do their hit on air. What plaintiff didn't know, as she and Mr. Gold set up to shoot the story, was that some 20 feet from where she was standing, on the other side of the 4 fallen eucalyptus trees, was a standing eucalyptus tree, tree number 10, which was approximately 75 feet tall. And when I say tree number 10, I only identify it that way because in some documents we'll show you in a minute, you'll see where a tree number 10 is identified as a tree that should have been removed. So tree number 10 posed a significant and imminent threat of harm. Though plaintiff and her cameraman didn't know that this threat of catastrophic harm loomed large over them, the defendants did. Can you go to the next slide, please? Some 2 years earlier, at a time when a eucalyptus tree fell and crashed into a unit on their property, the defendants had hired a certified arborist, Andy Biondolillo of the Forestry Group, to conduct a survey of the Quest property and propose a tree care plan. In conversations with the defendants in this case, Mr. Biondolillo recommended removing all of the eucalyptus trees among Myolinda Road for safety reasons. Can you go to the next slide, please? So you can see here where Mr. Biondolillo recommended removing 17 trees. When the defendants rejected his plan, ostensibly for financial reasons, Mr. Biondolillo scaled his recommendation back to removing 11 eucalyptus trees, including tree number 10, which is the tree that ultimately fell on Marie Coronel, and he put this recommendation in writing. Can you go to the next slide, please? Well, you can see the cost was 29. There you go. So these are the ultimately the 11 eucalyptus trees that Mr. Biondolillo recommended on a scaled back recommendation, and you can see it included tree number 10, which is this tree. However, even though they approved the revised plan, so if you can go to the next slide, please. You can see where the Homeowners Association approved the plan for Mr. Biondolillo. The Homeowners Association made a decision to hire a landscaper to do a walkthrough and give a second opinion. Go to the next slide, please. So based on the second opinion, the Homeowners Association decided to remove only 5 eucalyptus trees along Myolinda and push the rest, including tree number 10, to 2015. As you can see, so can you go to the next one, please? So, I'm sorry, yeah, so this was this one, yeah, thank you, Ivan. So what they ultimately decided was, quote, "We have no choice but to move forward at this time. We will be having more serious problems than what we already have. The $16,000 bill will be reimbursed from the insurance company. I will ask Forestry if they will do a payment plan." So clearly, the Homeowners Association was trying to cut corners, cut costs. They understood what the risks were of the trees, yet decided, at least at that point in time, to push removal of several of the dangerous eucalyptus trees into 2015. But despite this fact, as of the date of this incident, on February 1st, 2016, tree number 10 was not removed. Thereafter, during the storm that passed through San Diego in the end of January 2016, 4 of the eucalyptus trees surrounding tree number 10 fell, and residents in the Quest property noticed that tree number 10 was likely next to fall. Though they were aware of it, that this was happening, the defendants took no action, declining to warn the public of a specific danger posed by tree number 10. In the early morning hours of February 1st, after plaintiff and her cameraman set up for their shot, plaintiff filmed a short live shot for the morning news. Still completely oblivious to the extraordinary risk of harm that hung over their heads, they began preparing to film a second live shot for the 5 a.m. news. During these preparations, tree number 10 gave way, falling to the ground and striking plaintiff, causing her serious harm. Marie Coronel was hospitalized for 11 days and underwent neurosurgery for a fractured spine. She suffered a broken clavicle, a broken sternum, and multiple broken ribs. Her active pregnancy was harmed, and she also suffered a mild traumatic brain injury. So now let me kick it over to Ivan, and Ivan will talk to you a little bit about the nature of the trees and some of the more technical aspects of what to look for in these types of cases.
Thanks, Scott. Before I launch into this, I want to share what was my main concern in this case, which was that this was a healthy tree. Often in the tree cases, There could be fungus, rot, a tree that's just too old, something going on that the tree's sick and should have been identified and moved. Here you've got a healthy eucalyptus tree in the San Diego area, which is literally covered with eucalyptus trees. And we had to convince a jury that this large, mature, very old eucalyptus tree should have been removed because it posed a danger. So how did you go about doing that when jurors love trees, they don't want to remove all the trees, and you have to say you have to remove this healthy eucalyptus tree? So what we really focused on was not to take on all eucalyptus trees and say they should never be planted, which is in fact how our arborist feels, but we didn't think that would work with a jury. We focused on why this was the wrong tree in the wrong location. If you look at this slide we've got on the screen here, this is part of Beyond a Lillo, the arborist that Quest hired. Part of his report, he identified that the eucalyptus trees, not only did some of them have trunk liens, but that eucalyptus trees in turf areas have shallow roots. And once the soil becomes soaked, failure of the trees like this increases. So why is that important? Because you've got grass, turf around all of these trees, and they're being watered every week. And what happens is the roots seek the water. So they come to the surface instead of going deep into the ground. And you have almost all the roots for these giant 80-foot tall, sometimes trees, just in the top 6 inches of the soil. When you get a big rainstorm, often when trees fall due to wind, it's because there had just been rain. The water moistens the soil and the roots have more play and can move around more when that soil's moist. And then a big wind comes and then it's able to topple the tree, especially if you've got very shallow roots. So the fact that Beyond a Lillo had put this into the report was really helpful, and that kind of became a focus of our case of why these particular healthy trees should have been removed, because our arborist went and looked at the tree and he couldn't find any problems with negligent trimming or maintenance. So we had to focus on the species and actually the subspecies of the tree and the conditions it was growing in. So the subspecies within eucalyptus was called the Cadacalyx, also known as a sugar gum. These are some of the most prevalent eucalyptus trees in all of Southern California. A little bit of history there. These were all planted originally in the 20s and 30s. People thought they would make good wood for railroad ties because the trees grew so quickly and we needed a source of lumber. It turned out they didn't make very good wood for anything, but developers liked them because they grew so quickly. And because they had the ability to grow so quickly, they were planted in a large scale, as I'm sure all of you have seen throughout California, particularly Southern California. So when we deposed the arborist for the other side, we went into the subspecies, and he actually admitted that it had a higher risk of failure as opposed to other types of eucalyptus trees, partially because it grows so tall. And one of the things I did was I kind of went into the history of this subspecies of eucalyptus tree and looked at where it grows natively in Australia, because we wanted to draw up the comparison of why the conditions of having it grow in grass in a condominium where you're going to have shallow roots is so dangerous. So if you look at its native habitat in Australia, it only grows in 3 areas in southern Australia. One of them is the Flinders Mountain Range, which is where this picture is taken. Next to there's Kangaroo Island, where they grow. And these are all very arid areas with poor soil, a lot of stones in the soil. There's nothing resembling turf or grass where these things grow in nature. And part of the reason that's important is because they don't grow as tall in nature. The tree we're looking at in the photo, maybe that's 40, 50 feet tall max, and it's one of the big ones. In San Diego, these trees could grow to 80 feet in turf because they're getting so much water. And the reason that's dangerous is all that water creates a big, healthy canopy, especially near the top of the tree, and that canopy acts as a sail. So when you get the really big winds, and the winds are stronger the higher you go, 80, 100 feet off the ground, and they catch this huge canopy, there's enough force to topple one of these trees in a way that really wouldn't happen in nature. So it's really the wrong tree, the wrong subspecies of the tree in the wrong location. And this is just a slide showing some more information about where this tree comes from, what we already talked about. And my partner, Bruce, one of the things he likes to talk about is that jurors enjoy when you're able to teach them something, and tree cases are really good for that. There's a lot of interesting facts, I think, that you can teach your jurors, and they'll appreciate that, and hopefully lean your way as a result.
And Ivan, I think in the end also it makes sense because, you know, you can teach them all about the trees, but it really comes down to the fact that the trees grow tall and they have shallow roots. And you just have to know what the species and subspecies are that have those characteristics, correct?
Correct. Because I could just imagine the cross-exam if our arborist said, you know, all eucalyptus trees should be removed, and then the cross-exam could go like, well, this is San Diego. We've got 50-foot eucalyptus trees lining all the freeways where they could fall on cars, and the city and the county don't seem to mind that. They don't think it's dangerous. And part of the difference is those trees aren't usually growing in turf, but again, it's important not to take on the whole species and figure out why it's the wrong tree given a particular location. So, battle of the weather experts. This case and then another case we'll talk about later, the Burke case, also in San Diego. A huge part of the evidence turned on weather-related issues. So both sides had to hire meteorologists, and it played out very similar in both cases. In Coronel, this was a really huge storm, but the defense meteorologist, you know, he tried to make it into the storm of the century, which it really wasn't. Although it was what he called a 50-year storm. And here's some of the characteristics of that storm. We had 50-mile-per-hour winds. Those were recorded at the airport, which is a wide open location, so you're going to get higher readings there. Hurricane force winds, meaning like above 70 miles per hour at other weather stations. Again, the defense meteorologist, he went and got readings from canyons, from the tops of mountains, wherever the wind was the strongest. In the Burke case, we actually had the defense weather expert take readings from the stratosphere, where it was hundreds of miles per hour. We actually had to do a motion eliminate to exclude that because, you know, he was trying to imply that there were 300-mile-per-hour winds when those were up above the clouds, not where the tree was. There was rain, which is important because it loosens the soil. And another difficulty in this case is we had 500 tree failures on the same night that those trees fell at the Quest condominium, including the one that fell on Marie Coronel. Our weather expert, he focused on more local readings closer to where the tree fell, and the time right before it fell, because it went to notice how dangerous did the scene feel when Marie and her cameraman arrived there. So the day before, the wind gusts were generally 15 up to 25 miles per hour. So if you've got a healthy tree, even with rain, it should not be falling at 25 miles per hour. Right before the incident, the wind was 7 to 14 miles per hour. Again, not so dangerous that she assumed, you know, the risk of being killed by a tree going out there. If you look at the video, you don't see much of a breeze. At the very end, her hair kicks up just a tiny bit. There's a small breeze going, but it's not a hurricane force wind by any means. And the main opinion of our weather expert was that a healthy tree is not going to fall in 25-mile-per-hour wind gusts, and that the wind gusts recorded closer to the area of the subject incident were less strong than the ones recorded at the airport, where you've got, again, a wide open space.
And that was all important because the defense in this case kept trying to portray this incident as having occurred during the storm, when clearly it occurred in the aftermath of the storm. And that's why the battle of the weather experts was so important, because we needed to show that the storm had cleared out. As you can see in the video, there really wasn't much going on. And I think that was sort of the key fact in the case.
Exactly. And we've all seen the weather person try and get that amazing shot. They're being blown off the camera and they're standing there in a hurricane. And if they get hit by a tree, you kind of tend to think maybe it's their fault. But in this case, it wasn't like that. She thought the storm had passed, and we kept calling this an aftermath story. It wasn't a live in the middle eye of the hurricane type of reporting story, which is how the defense tried to portray the case. So just following up on that last slide, here's a map showing different weather reading locations. This pin here on the right in the middle of the mountains, of course, that's where the defense weather expert tried to get their readings, in addition to the airport, where you get really big winds. But in the neighborhoods where you've got flatter areas with buildings acting as windbreakers, it really wasn't as extreme at all. One of the things you want to do in these cases is get all the presentations that your defense arborist has ever done, because they will likely talk about different species and which ones are dangerous. I can tell you that the 3 top species in terms of failures in California are eucalyptus, oak, and pine. And most cases that I've worked on have dealt with those 3 species, in fact. So there's a good chance you'll find a defense arborist who's done a presentation where he considers these species dangerous, and that's a concession you'll probably get, that they're more likely to fail. When you're talking about removing a tree, the factors that you look at in addition to species is it a high target zone, meaning do people regularly walk in that area? And what's the probability of danger if it falls? So in this case, we had a high target zone because it was a sidewalk right by where the tree fell. And most arborists will admit that if a tree is a dangerous species, meaning it has a propensity to fall and is in a high target zone, it should be inspected on a yearly basis. Important discovery in this case was finding out the HOA budget because they decided they didn't want to spend the $29,000 to remove all the trees that were recommended for removal. And while $29,000 is a lot of money and sounds like a lot of money, when you put it in context, they had a $749,000 operating budget. They spent $217,000 just on water for their landscaping and $76,000 on a landscaping company. It doesn't seem unreasonable to ask them to remove trees when an arborist tells them it's posing a danger.
And oftentimes when you look at the budgets, you'll find things like where they've thrown parties for the residents, or they've held events for the HOA board. And those are the types of things that you want to look for as well, to show that sometimes they're prioritizing those social events over safety of the residents and people who visit the community.
Right, and here I think they had a budget item to repaint their deck chairs at the time they weren't replacing the, following the tree recommendations. So another thing you always look for in every case is notice. Here it's a big property, so we have notice from other trees falling. There's always going to be a big fight over whether they're sufficiently similar to come into evidence. To provide evidence of notice, but here we found a history back in 2010. They had other eucalyptus trees come down on the property. I think at the end we were able to get an evidence of other eucalyptus trees, but our judge excluded evidence of non-eucalyptus trees that might have fallen on the property. We had a summary judgment in this case where the main issues raised were assumption of the risk and open and obvious condition. And Scott, do you want to go ahead and talk about?
Yeah, let me talk a little bit about this, Ivan. So our position on assumption of the risk was that assumption of the risk doesn't apply. And our secondary position on assumption of the risk was that if it does apply, that it's not subject to summary judgment here because there's triable issues as to whether they increase the risk of harm. So just to go back just for a brief primer on assumption of the risk. Assumption of the risk is really a duty analysis, at least primary assumption of the risk. And if you look at Knight versus Jewett, it talks about how by virtue of the nature of the activity and the party's relationship to that activity, did the defendants owe a legal duty? And that's how it usually arises in the sports context. And in most cases, you'll see primary assumption of the risk in the sports or recreation context. The other context is where someone seeks relief for the very risk that they're being paid for, something that's typically called the firefighter's rule. And I think that was sort of the basis on which they raised primary assumption of the risk here. But again, in our view, it didn't apply. Can you go to the next slide, please? So when we look at, did Marie Coronel assume the risk? These are the arguments essentially raised by the defense, which is that she crossed police road closures in her vehicle, that she crossed the yellow police tape, that she had known that 4 trees had already fallen, that she knew this was a severe storm, that she placed herself in the middle of the trees for the most dramatic shot, and that she never inspected the trees in the area. Now, let's stop here and look at what they were arguing in terms of her assumption of the risk. They were arguing her conduct. And in cases of primary assumption of the risk, the focus isn't really on her conduct because it's a duty analysis. When you're going to focus on the conduct of the plaintiff, it's really a secondary assumption of the risk argument, which goes to issues of comparative fault. And that's what we argued. Why don't you go to the next slide, please? So this was the road closed sign when they said she crossed the police road closures in the vehicle. But again, she and Mr. Gold believed that that the sign was there because there were trees that had fallen across the roadway, and that they certainly were permitted to go there to set up for their shot. Go to the next one, please, Ivan. So they also raised the issue of her crossing the police tape. And this is some of the testimony that they relied upon from an officer, Kwiatkowski. Now, I have to tell you, Officer Kwiatkowski was himself a character. I guess I would describe him as a true believer police officer, someone that, in my view, exaggerated his importance to try to stoke his own ego. But he was pretty strident in his position. And as you can see here, he said he had put up yellow police tape to cordon off or perimeter the area from Mile Linda Road and Carroll Canyon, and that he used several rolls of police tape, and they put out cones, and his position was they were really trying to keep people out of the area. I can tell you that Ms. Coronel, when she went to the area, saw the police tape, as we said earlier, on the ground, felt that it was merely to protect people from where the trees had already fallen and to provide a warning that those trees were already there. But certainly it wasn't as though she believed they were crossing a barrier that they weren't allowed to cross. Although, if you go to the next slide, as a member of the press, under the law as it existed, she was allowed to be there. And I remember when Ivan and I raised this issue with the defense, they actually appeared to be taken aback because they weren't aware, I don't think, of the fact that nothing in this section shall prevent a duly authorized representative of any news service from entering the area closed. After being advised of any existing danger, members of the news media are permitted free movement in the area as long as they do not hamper, deter, or interfere with law enforcement or public safety functions. So we were able to find the law that said even if that police tape was up, that she and Mike Gold were permitted to cross that police tape as members of the media. And again, you know, it was only through the thorough research, primarily by Ivan, I don't take the credit for it, who found this section that was able to help us overcome these arguments. You go to the next slide. Oh, I'm sorry, go ahead.
I don't think any of the officers, 3 of whom were deposed in this case, knew the law either. They were all asked by the defense attorney. She broke the law, didn't she? She crossed the yellow police tape. She's not supposed to do that. And they all agreed. And then we found this penal code section, which prevented them from arguing that.
Yeah, not surprising that they didn't know the law, especially Kwiatkowski in this case. So in talking about primary assumption of the risk, again, it's a legal duty and it's a non-delegable duty that they have to adequately maintain their property. So as you can see, defendant has a duty of care to the plaintiff to eliminate dangers on the property. You can see the other case authority, which we put in here so that you all have access to it, that we can provide you a copy of the PowerPoint when this is all done. But importantly, if you look at the 4th bullet, it says the court explained that it does not matter that the plaintiff was aware of the dangerous condition at the time he fell, because, quote, in determining whether assumption of the risk applies under the duty approach, our inquiry does not focus upon the reasonableness or unreasonableness of the plaintiff's conduct. Rather, resolution of the issue turns on whether, in light of the nature of the activity in which the defendant, landowner, and the plaintiff were involved, the defendant and landowner's conduct breached the legal duty of care to the plaintiff. So that merely highlights what I talked to you about earlier, which is that when you're talking about primary assumption of the risk, it really is a duty analysis and you don't look at the conduct of the plaintiff. And in a whole variety of circumstances, in different cases that you'll see the defense try to conflate primary assumption of the risk and secondary assumption of the risk, where they'll focus on the plaintiff's conduct and claim that somehow it operates as a complete bar, where the law makes clear that it doesn't. So just make sure that you're up on the law in that area. If you go to the next one, Ivan. So these bullet points deal with the argument that even if primary assumption of the risk applied, that triable issues of fact exist as to whether the defendant increased the risks that were inherent in the activity. And so you'll see in the second bullet point below in the highlighted portion where it says summary judgment on primary assumption of risk grounds is unavailable unless the defendant disproves the theory it increased the inherent risk. So keep in mind, again, that even if you're in a situation where either the firefighter's rule applies for primary assumption of the risk, or you have a primary assumption of the risk issue in a sports or activity context, that you look to see whether any of the defendant's conduct increased the risks inherent in the activity. If they did, then you can overcome primary assumption of the risk. And if there are questions of fact on it, you can certainly overcome a primary assumption of the risk argument for summary judgment purposes. All right, now we can go to the open and obvious argument. So a claim that a danger is open and obvious is typically an argument for comparative fault, except in the warnings context, which I'll talk about in a minute. So open and obvious potentially reduces defendant's proportion of liability. It typically doesn't function as a complete shield to liability. So here, from a factual standpoint, the question was, what was open and obvious about the scene that Marie Coronel visited after the storm? This gets back to the point we talked about earlier about whether she put herself in danger by going during the storm or whether she was there in the aftermath of the storm. As you can see by the video that we showed, there were no obvious dangers present to Marie, so there's nothing that would have been open and obvious to her in terms of danger. But even if it was applicable, as the law that's before you on the screen highlights, it's typically a comparative fault issue. The only context where it can really be a complete defense is in a failure to warn claim, and that would be under CACI 1004, which talks about obviously unsafe conditions, which says if an unsafe condition of the property is so obvious that a person could reasonably be expected to observe it, then the owner or the person who controls the property does not have to warn others about the dangerous condition. However, the owner, the one who controls the property, must use reasonable care to protect against the risk of harm if it is foreseeable that the condition may cause injury to someone who because of necessity encounters the condition. So where you have an argument that the defendant should have warned of the dangerous condition, that's where if it's obviously unsafe, where the open and obvious argument could arguably lead to a complete bar. But that being said, the defendant still has the obligation to take reasonable care for the maintenance of his property. So if you go to the next slide, Ivan. So typically what you would do is you would do a traditional duty analysis when it comes to a premises liability case when we're talking about trees on private property. Now again, there are different rules, some different arguments that apply in private versus public, and we'll get to those a little bit in the presentation. But in terms of private property, you would look to the factors in CACI 1011, which talks about in determining whether defendant should have known of the condition that created the risk of harm. You must decide whether under the circumstances the condition was of such a nature and existed long enough that they had sufficient time to discover it and using reasonable care either repair the condition, protect against harm from the condition, or adequately warn of the condition. Importantly, defendants also must make reasonable inspections of the property to discover unsafe conditions. An inspection wasn't made within a reasonable time before the accident. This may show that the condition existed long enough so that the property owner using reasonable care would have discovered it. They can't bury their head in the sand. That's really what this comes down to, is they have a duty to make reasonable inspections. They can't bury their head in the sand and say, clearly I didn't know about it, but I didn't conduct any inspections or make any attempts to determine whether there were any unsafe conditions on the property. So if you can go to the next slide, please. So in deciding whether defendants use reasonable care, you can consider, amongst other factors, the location of the property, likelihood that someone would come onto the property in the same manner as Marie Coronel did, the likelihood of harm, the probable seriousness of the harm, whether defendants knew or should have known of the condition that created the risk of harm, the difficulty of protecting against the risk of such harm, and the extent of defendant's control over the condition that created the risk of harm. Again, it's a general, typical duty analysis for a dangerous property case. And if you look at the various factors here, we think that we were able to tick all the boxes in terms of the fact that they didn't use reasonable care because they had actually conducted an inspection and made the decision not to remove the dangerous trees. Because of that, there was likelihood of harm, and that if a tree, 70-foot tree fell on you, that the consequences could be serious. And so again, having prepared for trial, we think we were in a good position to prove these elements to the jury, which is, I think, what ultimately led to the settlement. So they knew that there was a hazard, but they did nothing to protect against the risk of harm. So Ivan, why don't you talk a little bit about what it is that you do when you first get these cases and what you need to do to make sure that you've got everything in place to move forward.
It's really important to move fast in the beginning of a tree case because the evidence you're going to need to prove your case might be in the form of disease or damage or improper pruning that you can only glean from looking at the tree itself. If it's not a whole tree that fell, maybe just a branch fell, you're going to need to see that branch. And often when it falls, especially if it's a public entity, it's going to end up in the wood chipper within days. So not only would I send a preservation letter immediately, I would also go to the scene immediately, preferably with an arborist if you can, to inspect the tree, inspect the fallen pieces of the tree, and get really good quality photographs. You may even need samples to take back to a lab to find out what kinds of fungus were growing on the tree and how long they were growing there. And this all goes to proving notice in the case. Then you're going to want to look at historical images, and Google Maps and Google Earth are great for this. I suggest, in addition to Google Maps, actually downloading the Google Earth software, because it sometimes gives you additional photos that aren't available on Google Maps. It lets you easily save them as JPEGs, which often looks better than just doing the screenshots off of Google Maps. So one case where Google Earth saved our whole entire case was up north of Sacramento. We had a pine tree in a very undeveloped area fall, and it fell on top of a car that was in this parking lot. And unfortunately, our client's mother was sitting in the car, and she was killed when this tree branch fell. Actually, most of the tree fell, 2/3 of it fell. And when we took the case, we didn't know who owned the land. Had it been public land, it probably would have been subject to the natural condition immunity that we'll talk about later, because anything that's in an unimproved state on public land is subject to that immunity because it's in its natural condition. Fortunately, in terms of recovery, this turned out to be private land, although it was completely undeveloped next to the parking lot. And so this pine tree fell, and we were able to go to Google Maps and look at historic photos from several years earlier. And what we saw, this is the tree before it fell, and it had no green needles, which means it was completely dead, and it had been dead for some time. And you get a date on these Google images. So we knew this was from 2012, and we were able to get various photos and determine when the tree had died. And we figured out that the tree died more than 5 years prior to our incident. So even though this is not an area where you get a lot of people, it's not developed land, if you've got a tree that's dead for 5 years, you should be removing it if it's right next to a parking lot that's within the strike zone of the tree, if it's going to fall. Also, through these photos, our arborist was able to see this kind of notch in the tree down here where it started growing crooked, and that gave him a clue as to why the tree was unhealthy and ultimately died and had grown the way it did. And here's a close-up showing no green on that tree. And this is what was left of the tree after the broken piece. This was another case where it was a storm and pretty high winds where the tree fell, sorry.
So Ivan, so just to be clear, when we were talking about Coronel, we're talking about trees actually falling, but cases can exist whether the entire tree falls or whether just a portion of the tree, or what we would call limb failure, occurs, and a portion of the tree can fall and hit someone and cause damage, correct?
Correct. We had one case that a ficus tree right outside of City Hall here in LA fell on our client who actually worked at City Hall, and she was just coming out after her day at work, and a giant limb fell and hit her on the head. And in that case, it turned out that that branch failed because of improper pruning techniques that caused it to be weaker. And even though we lost the limb, we were able to look at the break point and follow that branch down to the trunk of the tree and figure out how it had been improperly pruned in the past. And when you're dealing with a public entity, it's either notice from seeing a dangerous condition or creating that dangerous condition. And so the pruning itself created the dangerous condition because it made the tree branch grow weaker than it would have had it been unpruned or pruned properly. So when you're looking at causes of tree or limb failure, a disease is a big one, pruning. Topping is something that is not common anymore, but it used to be very common. there's a picture of it here. Basically, it's what it sounds like. They take off the whole top of the tree. This leads to what's called epicormic growth, where you get these smaller, weaker branches growing out of the topped area. And when those branches become very big and heavy and have weak attachment points, they're very prone to, to failure. So this is another case that Scott and I had against the city of Los Angeles, where a eucalyptus tree that was in Westwood fell on our client's vehicle. Two parents and their daughter had been visiting UCLA to tour the campus. That's the campus actually on the right side of the photograph here. And these are some apartment buildings across the street. And they were just driving slowly down the street, and unfortunately for them, a giant branch fell on their car, and the mother, who was sitting in the back seat, suffered a fractured back as a result. So this case was against the city of Los Angeles, as well as the apartment complex. One of the things to keep in mind, when you have a tree failure in this area that we call the parkway between the sidewalk and the street, it can often be a situation where there's ownership and control that's shared between the private property owner that may own the parkway, but the city which controls it and exercises that control by doing the maintenance. So that's why we had both defendants in this case. So you can see in this picture, this is a Google Street View shot of the tree before it failed. This is the big limb towering over the street that fell on our client's car. And our arborist came out and looked at the tree, and he quickly saw that it had been topped a long time ago, probably over 20 years ago. And you can, if you kind of look at my mouse here, you see there's this whole area where all these thick branches and trunks all of a sudden become thinner, and all these smaller branches grow out of it. So when it gets long and grows out over the street, it's more prone to failure because of that topping that occurred years ago. I actually deposed arborist from the city of LA who said that they made it their policy to stop topping trees 30 years ago. But sometimes they hire independent contractors to do the tree trimming. So either this was topped, maybe it was topped 30 years ago, or maybe they just hired a contractor who did this pruning incorrectly. But they agreed with our analysis that the tree had been topped. So it led to a settlement in that case. Here you can see the break point on the tree. And this is a tree that didn't have any disease. It was an otherwise healthy tree, but it was improper pruning techniques that led to the failure.
All right, so let me talk a little bit about this, Ivan. So there's different considerations when you're dealing with a public entity tree failure case versus a private case. And in the case that Ivan did with Brown and with Balaban and Spielberger down in San Diego, which was the Burke versus City of San Diego case, it was a hybrid because this parkway area that you see in the photograph was under the joint control of both a private entity and the City of San Diego. And let me just give you a little brief overview of the facts in Burke, and then Ivan can talk a little bit more about the case. So in this case, Mr. Burke was a lawyer down in San Diego, and a tree had fallen on his car. And so he had called his friend to come pick him up to take him in to work. And as his friend got there, he realized that he had left his computer and some other files in his vehicle. And he went to his vehicle to retrieve the computer and the other files. As he got those and went back to his friend's car, a second tree fell on him and crushed him as he was putting the materials in the friend's car. As a result of the incident, unfortunately, Mr. Burke suffered permanent nerve damage in both legs. That case actually had to be tried and resulted in a $7.7 million verdict, approximately. So Ivan, that's a little bit of the background. Why don't you talk about some more of the specifics?
Sure. So looking at this photograph, the car in front, that is Michael Burke's car, and his house is right here across the street. And he woke up in the morning. There was a storm going. It was raining. He saw his car was crushed. He got a ride from a friend driving this Honda. On his way to work, he realized he forgot his laptop. So they came back. He was going to jump out of the friend's car, get his laptop from his trunk. And then when he was going to put his laptop and briefcase here in the back of his friend's car, that's when the second tree right here fell. And you could see his shoes here. It crushed his legs. And even though he wasn't a paraplegic, he did lose use of his legs as a result. Here's an animation that shows what happened. And it just missed his head, fortunately, but again, it did crush his legs.
So if I can just stop you for a second, I think someone just asked the question is who tried the Burke case. It was Ivan and Brown along with Dan. Dan, correct? Yeah.
Correct.
Gotcha.
So when you, on the issue of notice with a public entity, you have to show that they either created the condition or it existed long enough that they should have known about it. San Diego used to do inspections of all their trees, and here's an example from one bid that they had for contractors to come and inspect trees. They used to inspect most trees on an annual or biannual basis until the economic crisis in 2007. Then all the tree inspections stopped. The city began relying on homeowners to report trees, and they would just come out on an as-needed basis when someone called to complain about a tree that an untrained homeowner thought looked dangerous, and then maybe come out and trim it. But they were no longer being proactive about tree trimming, pruning, or maintenance. And there was no inspection system after 2007. So we called this the ostrich defense. Basically, the city was sticking its head in the ground and saying, look, we didn't know the tree was in a dangerous condition because we didn't have the budget to go out and inspect it every year. So we had no notice, and therefore we can't be responsible. A dangerous condition of public property, what you need to prove, and here's the CACI instruction, is that it creates a substantial risk of injury to members of the general public. When you're talking about, in this case, it was a 75-year-old, very tall queen palm, the risk of injury is huge. It's probably death or a very serious injury like this case. And a city cannot have an inspection system. They're not legally required to, but the jury is allowed to consider that in deciding whether or not a reasonable inspection system would have revealed the dangerous condition. And if you only actually get one thing out of this entire webinar that deals with public entity cases and trees, it would be this. Because very often the city is going to say, we didn't have the budget, we couldn't go out there, we didn't know that there was a problem with this tree, so we just didn't have notice. And that's not a, get out of jail free card for the city. A jury, again, can look at whether a reasonable inspection system would have revealed this dangerous condition. And they consider, in evaluating that, the practicality and the cost of the system, and they balance those factors against the likelihood and seriousness of harm. So you have to do discovery on the city's budget, what they were spending things on, the cost of doing inspections, and whether all that was practical. And for example, going back to the Zhang case, the one right outside UCLA that we discussed a few minutes ago, I deposed a tree surgeon from the city of LA in that case, and he testified that as of 2018, the City of LA trees were on an 18-year trim cycle. And within those 18 years, inspections would only be performed upon request. So they're not looking closely at trees. City of LA has a very low budget compared to other cities. I think they spend half of what New York spends on trees. Melbourne, Australia spends 5 times as much as LA does on inspecting its trees, to give you an example. So we basically are just reacting, waiting for an obvious sign of danger, a homeowner to call, and then they go out there and inspect. They're no longer doing annual, biannual inspections of all the trees. So when you're dealing with a reasonable inspection system, you have to prove causation, right? So what would an inspection system have revealed? So here, that's a historic picture from Google Maps of the tree that fell on Mr. Burke. And our arborist was able to look at these historical photographs and testify that, had they inspected this before it fell, here's what they would have noticed: that there's a narrowing of the trunk that they call penciling, that the fronds were less than 10, which is very little for a healthy queen palm, and that there's lack of roots, and the color of the fronds was brown, also indicating poor health. Now, the lack of roots is a tough one because in terms of notice, they're usually in the ground. So poor root system, if a tree looks healthy but has poor roots and falls, you can have trouble arguing notice against the city. Burke was really unusual in that the morning of the storm, the lead foreign urban forester for San Diego was actually driving around in his car looking at storm damage. And he drove right by the first tree that fell on Mr. Burke's car. And when he drove by, he actually took photos, including this photo right here. And he could see that the root system was poor just from the tree that had become uprooted. So they actually had noticed just from hours before the incident that there was a poor root system. And they came and put police tape around the area, but they didn't do so in a way that the tape remained up or really provided any sufficient warning, which we'll talk about in a bit. So there's a picture showing, how undeveloped the root system is compared to a healthy palm tree that's got this big root ball holding it in the ground. There's a close-up of what the roots look like when the tree was uprooted. So the defense excuses, the big one is it was an act of God. You had a big storm, nothing we can do. Hundreds of trees, fell in the same storm. How did we know that this tree was going to fall? Another defense you hear a lot is summer limb drop when you have limb failures. Summer limb drop isn't a pathology or a disease. It's just the term given for a phenomenon that sometimes trees drop limbs and they can't explain why it fell and they call it summer limb drop. So the plaintiff's arborist's job is, to try and figure out the real reason it fell, whether it's disease or pruning, instead of just attributing it to an unexplained phenomenon. So similar to Coronel, we had the battle of the weather experts in Burke. We looked at hurricane studies, and a study from the University of Florida showed that 74% of queen palms survived 120-mile-per-hour winds. So that's much more significant than anything that happened in San Diego. And the takeaway where the winds were 35 miles per hour. So the takeaway is that this is a survivable event. A healthy tree, a healthy palm tree especially, should not be blown over in 35-mile-per-hour winds. On a related point, the weather expert will say this is a 50-year storm. So if this is a weather event is so big, it only happens once every 50 years, you can't blame the tree for falling, or you can't predict that that this is going to happen because it's such a big storm. But if you've got a tree that has a lifespan of 90 or 100 years, then it's actually foreseeable that you are going to have 1 or 2 50-year storms while the tree is alive. So when making decisions as to whether to remove a tree, you argue that you have to anticipate there is going to be a 50-year storm. And these queen palms, for example, in the Burke case, they were all planted in the 20s. It was a donation from a lady in San Diego who gave them to the city, and they planted a bunch of them. And for decades and decades, they took care of those trees, they inspected and maintained them, and then they just completely walked away from that duty in 2007. So we argued it was not an act of God, but it was a failure of maintenance.
Ivan, on the act of God defense, that's the one that I think they think the jurors can latch onto the easiest, and that's why they raise it. I think it's one of those defenses that is easily beatable when you actually start to put the facts together, but that's really the defense I think they use to try to appeal to the jury's, just general beliefs. Is that what you think as well?
Absolutely, and it's a good area to voir dire on, and find your jurors that are going to be more receptible to that act of God defense, because you're going to hear it in every case.
Well, and I know I've spoken with other lawyers who've actually rejected these cases because they've rejected them out of hand because of their fear of the act of God defense, but that's never been a successful defense in any of the tree cases I've handled, and I don't think it's been a successful defense in any of yours either, has it?
No.
Gotcha.
So there was an alternate theory in the Burke case that, in addition to having notice of the dangerous condition, we argued that they were negligent in taping off the area. You see the yellow police caution tape here. It's strewn over the ground. The city didn't do a good job in putting it up in a way that would cover the area and tell people to stay away, because these two palm trees, they're twins, same size, planted at the same time. If this one fell, you shouldn't be walking next to this one, and they should have had an area blocked off. And we hired Brad Avery on that issue, and some of the jurors really responded to that theory of liability as well. And this is a mock-up that we did of what the tape would have looked like had it been adequately put up. And if this had been the situation, Mr. Burke testified he wouldn't have crossed this tape and gone to his car to get the laptop. But kind of a funny story about this case is where we got all these pictures showing the tree that morning that fell. Brown and Dan had taken the train to San Diego to depose an lead urban forester for San Diego, and they had no idea he had these pictures. And Brown showed up at the deposition early and was, I think, probably just sitting there reading the newspaper, and the witness comes in and he overhears him saying, "Hey, I've got all these pictures." And it turns out he was actually, what are the chances in the whole city, there that morning, and took these pictures of the first tree that fell and was in a position to identify the danger and do something to warn others of it, which was really just a random stroke of luck. This isn't something that was produced in a written discovery. I don't think the attorneys for the city knew about these photos either until the day of the deposition. So you've always got to be aware of the immunities when you're dealing with a government entity case. A couple big ones that apply to trees are the natural condition immunity. which it basically means if you're out in nature, you're hiking on any unimproved property that belongs to a government entity and a tree falls on you, that's not going to be a case. It's going to be subject to Government Code Section 831.2, the natural condition immunity. An example of when this immunity was recently applied was in Alana versus State of California. This is up in Northern California in the Portola Redwood State Park. Someone was in a campsite and a tree fell on them, and they argued, well, the campsite is improved property and that's where I was injured, so the immunity shouldn't apply. But the court held that since the tree itself was on unimproved property, and I think it was like a 80-foot tree that fell, that, you know, struck the campsite 60 feet away, that the immunity applied, because you look at not where the person was injured, you look at where the tree is located in deciding whether the immunity is going to apply. But then in a similar case, in County Mateo versus Superior Court, also involving a campsite in a, I think it was a state park, the immunity didn't apply because the plaintiff was able to show that there were tribal issues of fact as to whether the improved land had actually had an effect on the tree, because the roots of the tree had grown under a road outside the campsite, and they argued that the building of that road and compacting the ground led to damage to the tree's roots, which caused the tree to be unhealthy and contributed to the tree's failure. And because of that, because the improvement contributed to the failure, the natural condition immunity didn't apply. Trail immunity is another one to be aware of. Generally, anytime you're on any trail, and trails, you know, it's very expansive. If you've dealt with these cases, it includes bike paths, even when they're paved over with cement, any type of trail on public land. If there's a dangerous condition, there's trail immunity. But where a big tree branch from a eucalyptus tree fell on someone, is actually also in San Diego in the case of Taipei versus City of San Diego. The immunity didn't apply because the tree was actually 25 feet away from the path. And since the tree wasn't on the trail, it wasn't going to apply because the risk of harm is created by a tree off of the trail. That was actually Dan Balaban and Brown's case, and they took that up on appeal after losing summary judgment and got it turned around and created a little bit of good law there on trail immunity. Then there's the Federal Tort Claims Act. Just be aware, if you've got a case in a national park on any federal land and your case is going to come down to whether they should have inspected more or prune trees, there could be a discretionary immunity because maintaining those trees on federal land can be a discretionary act, and the discretionary immunity may apply on federal lands. Okay. So before I end here, just a final kind of thought about these cases. We're seeing more of them, and it's largely because of less maintenance by municipalities of their trees, and also with the weather warming and people conserving water more, trees are also more susceptible to disease and being unhealthy and failure. So be aware of these cases, and if they look really difficult when they come in your door, you know, take the time, consult with an arborist, because often it's not an act of God, and there really is a reason that could have been known that contributed to the failure.
Thank you, Ivan. And typically at the end of these presentations, when we get to the end, we save a little room for questions, and there were actually some questions. The first one, which several people asked, are what arborists do you like to use? Is there one particular arborist, or are there several? Who do you like to use in these cases?
Yeah, The arborist I use the most right now, his name is John Sevier, Sevier, and he's located in Texas, but he used to live and work in California. And if you've got a eucalyptus case, especially, he's the guy, because in his own private practice, he has probably responded to over 500 eucalyptus failures. So he can talk about that. He's not what I call an armchair arborist who just testifies. When he's not working on cases, he's actually up in the trees with a chainsaw. So very, very knowledgeable witness. If you have trouble finding him, and you contact me, and I'll give you his contact information.
Yeah, I've actually defended him in deposition on a couple of the cases that we've had, and he's fantastic. So I would certainly recommend him. And again, if there's other experts or other issues, here's the contact information for me and Ivan. Feel free to reach out to either one of us or both of us, and we'll be happy to get back to you. Another question that was asked is specifically about the Burke case, Ivan. In the Burke case, there appeared to be virtually no significant root structure at the bottom of either tree. Was that an issue in the case?
Yes, it was an issue, especially talking about notice the day of the incident. It was hard to say that the city should have known about the poor root structure, you know, a year before, because it's underground and it's not reasonable as part of an inspection to, you know, dig into the ground and look at how the roots are, assuming you could even do that. But because the first tree became completely uprooted and the roots were exposed, we were able to argue that the city had an opportunity to see the poor root structure and should have known that the tree right next to it, which ultimately fell on our client, was at great risk of falling. So they had a short window of notice, not time to move the tree from, you know, 8 in the morning when they saw it fall to saw the fallen tree to a few hours later when it fell on our client. But they had enough time to rope off the area and make sure nobody went there before it could be inspected properly and potentially removed.
Another question.
The city argued that, you know, they are not required to look at roots and had no notice based on the poor root structure.
Another question, Ivan, is what about palm fronds falling during or after windy storm conditions? This case is I have in mind is at Van Nuys Golf Course. So what about situations? Is there any hard and fast rule in terms of how to analyze a case where palm fronds fly off during a storm?
That's an interesting question. I haven't had that case yet. I think we all know that they do fall during storms, and if they fall right on top of someone, they could cause injury. I would ask an arborist for their take on that, whether they think it's important to trim the palm trees for that reason, so that they don't fall on people. I think it's a case worth looking into and consulting with an expert. And if an expert gives you that opinion, that given the location of the tree, which is important, because you're going to want to know if it's in kind of a high target area. If given the location of the tree, they would have recommended annual maintenance on the palm fronds, because my guess is this one that fell in your case might have, you know, never been trimmed or only trimmed every 5 years, and that's why it fell. Then it may be a case worth considering.
Yeah, and I think the answer is you know, with all of these cases, they're all fact dependent. And you know, when Ivan talked earlier about the things to do initially when considering the case, in order, one, to preserve the evidence, but two, to have the tree inspected to get an arborist out there as quickly as possible, you know, that's a little bit of money up front, but it certainly will save you a lot of money and headaches in the end if it turns out there's not a case. So, you know, the way that I would answer that question is the same as you, Ivan, although again, you know, sometimes it can be due to negligent maintenance, sometimes it won't be. And it's really all fact specific. So, you know, get the arborist out there as quickly as possible. make sure you've got the evidence that you need in terms of, whatever was available, that if, of course, any of the fronds are available or there's at least photos of them, the arborist is going to want to know what he's dealing with when he gets out there. Another question is, so what types of motions in limine do you typically see in cases like this? What are some of the more common ones?
Well, in Coronel, I think our most important motion in limine when you have a big storm event is to not introduce evidence of all the other trees that fell, right? Because you had 500 other trees fall that night, and the defense can get up and say, are you saying that all 500 landowners were negligent? I mean, come on, it's 500 trees fell. We can't predict which ones are going to fall. So we were able to argue that they couldn't produce any evidence showing substantial similarity between the other trees and the one we were talking about, or lay the foundation for why those other trees fell or didn't fall. And under 352, it would take an inordinate amount of time to do so, even if they could. So that's a really important motion in limine. And if anyone would like a sample of that one, just send me an email and I'll send it to you.
Yeah, and I agree with you on that, Ivan. In Coronel, I think that was ultimately the linchpin motion that resulted in the case settling, because if they would have been able to get in that all of those other trees had fallen during the storm, I think that would have been very persuasive evidence for the jury that, hey, this was an act of God. And again, it's not relevant what happened to other trees. What was relevant was what happened here, what did they know? And of course, in this circumstance, we were fortunate enough to find that they had inspected these trees, had slated them for removal. And this tree in particular should have been removed at the earliest 2014, at the latest 2015. And this incident happened in 2016. And so fortunately, we had a judge that was able to see through that, and very important, I think, for the outcome of the case.
Right, and I'll add to that, you have different wind conditions and different amounts of precipitation in areas where those other 500 trees fell. Similar to, I mentioned earlier, we had a motion in limine to preclude wind measurements from, mountain ranges and canyons that were far away and had more harsh conditions than the Condominium Complex where the tree fell on Ms. Coronel. So if you don't know what the weather was, what the wind was in those other locations, I know that in that big San Diego storm, Torrey Pines Golf Course had a lot of trees fall, but I also know that a lot of those trees that fell were subjected to even higher winds, and a lot of them were very old pine trees. So again, that's an important motion to bring.
And one of the things that you said too, Ivan, was that if anyone wants a copy of the motion in limine, contact us. We'll make sure we get to you whenever we can. Someone had also asked if we can post a copy of the opposition to motion for summary judgment. Again, if you contact Ivan or I, we'll help facilitate getting you whatever we can in order to help you or to answer any questions that we can. Another question that came in is very specific. It says, is it correct that if one residential neighbor plants a tree near but not on the property line, branches grow over the neighbor's property, the branch on the non-owner's property breaks and injures someone, the non-owner of the tree is liable? And then in parentheses says, large branch grows through chain link fence on the non-owner's property, that grows upward is what it says. Do you want to try to tackle that, Ivan? Or again, is this one of those case-specific type situations that's going to depend on the facts, that there really is no yes or no answer to that?
That is very case-specific. I haven't had that fact pattern yet. I would imagine that at least the property owner who has where the tree is rooted would also have some liability. But yeah, sorry, the only way I can answer that is I know that the non-owner's property has a right to trim those branches. So maybe because they have that right to exercise control, I could see some liability attaching.
Well, and there's a whole line of cases that deal with hazards on adjacent property. And so again, it's those cases that probably would form the basis for answering that question best. But I agree with you. I think the first place to look would be with the owner of the tree, and then look at the adjacent property cases to determine whether there might be liability on behalf of the non-owner of the tree. I think the last question we have is, how do you find these cases? And given that a lot of people don't think about tree cases necessarily as being viable cases, and I guess I would answer that as typically they find us, because people know that we've done these types of cases, we've tried these cases, we've settled these cases, and that we've had success on tree failure cases. So they seem to find us. I don't know if you can add any more to that. And then another question just came in when you finish with that one.
Well, the Burke case was a high-profile case that got a lot of media after the verdict in San Diego. And when people start looking for verdicts in tree cases, there's not a lot out there. So I think it's actually since the Burke case that we've started receiving a lot more calls on these cases. And
again, I think every case we've had, every tree case, I think, has been successful, either a verdict or has had a settlement that the clients have been happy with. So again, people have found us, and if you have anything that you want to talk to us about, if you have an ongoing case and you want to call to discuss it with us, we're happy to give you whatever insight, input, help we can. Or send us an email about it. We'll be happy to answer you. One of the main reasons we do these webinars is so we can be a resource, so that we can hopefully teach you something, but in the end be a resource for you, so that if you do have any questions after the webinar is over, or you want to pick our brains on any of this stuff, we're open and available to you, because we want to be able to help. So feel free to reach out to us. Feel free to give us a call or email. And Ivan or I would be happy to answer your questions. So that is it. I thank you all for attending. Please put on your calendars, as I said at the beginning, the next webinar in our series is Bruce Roylett and Alan Van Gelder on January 21st at 10 o'clock a.m. It's a confidential mid-trial settlement for fall through an unguarded skylight. And I can tell you that we've had many of these skylight cases over the years, and they're very nuanced. So you definitely want to tune in to that presentation. And there will be significant prevent issues that are being discussed. So it won't only apply to skylight cases, but will apply to other cases that involve prevent issues as well. So I would encourage you to do it. Again, if you have any questions about that webinar or how to sign up, feel free to reach out to us. Always be happy to help facilitate it. So thank you all so much, and we appreciate your attending.
Thanks, everyone. Bye-bye.